This Honorable Court of Criminal Appeals of Tennessee is in session.
Good afternoon, everyone, and welcome to this call of the November docket for the Tennessee Court of Criminal Appeals here in Jackson, Tennessee. We have the last case of the day to be argued before us. The rules of these oral arguments are just the same as if you were in person, 20 minutes per side, and if the appellant wishes to reserve any time, please do so upon beginning your discussion with us. You have a panel today that represents every grand division of the state. From Middle Tennessee, Judge Tim Easter. From East Tennessee, Judge Norma McGee Ogle. From Huntington, Tennessee, Judge John Everett Williams. I'm delighted to be here with you. I want to thank the staffs of Jim Hivner's office, the AOC, and indeed your staffs and our staffs as well for being able to get this technology running that allows us to have the arguments today. With that and no other preliminary matters being called, we'll call this case.
Dennis Joshua Cooper versus State of Tennessee.
Good afternoon, Your Honors. May it please the court. Brennan Wingirter with the Appellate Division of the Public Defenders Conference here for Mr. Cooper. May I reserve 3 minutes for rebuttal, please?
Yes, ma'am.
Thank you, Your Honor. This is a post-conviction appeal dealing with two issues. The first issue is whether my client's guilty pleas were knowingly and voluntarily entered. And the second issue is whether my client received the ineffective assistance of counsel during his plea negotiations. Now, we're asking this court to vacate the judgments and allow Mr. Cooper to withdraw those guilty pleas because of the constitutional errors in this case. And today I'd like to focus on the voluntariness issue, though of course I'd be happy to discuss the ineffective assistance claim as well if the court has any questions. I'd like to start by clarifying the two different legal standards for these two claims. The ineffective assistance claim, of course, we are under the Strickland two-pronged standard of deficiency and prejudice. But the issue I want to discuss today, the voluntariness of the guilty plea, has a bit of an easier standard for post-conviction petitioners. When this court is reviewing whether a guilty plea was knowingly and voluntarily entered, it looks to a variety of factors. These are the 5 factors from the Howell case that are discussed in our brief. Ultimately, the question for this court is whether Mr. Cooper's guilty pleas were a product of either ignorance or incomprehension. If they were, then those guilty pleas were not knowing or voluntary and must be vacated. Here, the 5 Howell factors all weigh in favor of Mr. Cooper. Now, I understand, and we cannot dispute that this is in the record, that Mr. Cooper said he was guilty, he admitted guilt to the crimes, and he said he knew that he took a 20-year deal. Now, the state wants you to think that that ends the question, but that's not the law. What our case law tells us in these situations is the court is supposed to canvass the entire record to determine whether Mr. Cooper understood what the plea connotes and what its consequences are. And the record here does not show that he understood that, Your Honors. Mr. Cooper cannot read or write. He has been through special education classes through all of his schooling. He testified that he receives disability payments for his mind, as he called it. He has always depended on his mother. He's lived with his mother in the past. He, at one point, was actually found, I think this was in the initial mental health evaluation, he was found incompetent to stand trial. And it took a few more evaluations before he was eventually determined to be competent, and then shortly thereafter entered the pleas in this case. When you look at, that all goes to his intelligence. That's the first Howell factor. When you look at the next couple of Howell factors, they go to the competency and advice of Mr. Cooper's attorney. Now, this is separate from the ineffective assistance claim as an entirely separate claim. So, but I do think that our arguments for why counsel was deficient, putting aside the prejudice prong for a moment, when we talk about whether his trial attorney was deficient in concurrently representing Mr. Cooper and his co-defendant, who was his ex-wife, when they were already separated and a divorce was pending, and trial counsel knew that and still represented both of them at the same time during these plea negotiations, those can all go to the competency and advice factors under Howell, even separate from the ineffective assistance claim. And then when you look at the record where it speaks to Mr. Cooper's prior familiarity with the criminal justice system, I think even that too weighs in his favor, because even though he had been through some cases before, and so perhaps we could say, oh, well, he knows how this works. Mr. Cooper testified that in all of these cases, because he is what he calls himself a slow learner, he's just sort of goes along with what his attorney or other people tell him to do. He assumes that other people know better than he does because he recognizes his own learning disabilities and mental health issues. And so that's borne out by when he was asked, well, did you talk to counsel about discovery? His response was about whether they reviewed the motion. And then when he was asked about some prior guilty pleas that he had entered, he talked about a case that he thought had been dismissed. And so even when we look at his history, everything in this record points to him not truly understanding what he was agreeing to or what the consequences would be when he took this 20-year deal, as he called it. And the record beyond Mr. Cooper's own testimony, his own learning disabilities and mental health deficiencies, and we argued this in our brief, that anyone of ordinary intelligence looking at these plea agreements would be confused. And that's borne out by the number of errors between the plea agreements that were then reduced to the judgment forms. I caught a few errors. The state caught a few more that I had missed as well. And you'll see this when you look at the record. There were 4 docket numbers, 2 different plea agreements, each covering 2 of the 4 case numbers, multiple charges within each one. For one of the plea agreements, I believe it's pages 32 and 35 in the technical record. One of those appears to be a replacement page for the first page of one of the agreements. It's unclear when the changes were made. On both of these plea agreements, they have several different handwritten notations. One says effective 10 years, or it's EFF period. I assume that means effective 10 years. Right under that, there's a notation effective 20 years. The other plea agreement just says effective 20 years. Both plea agreements check the boxes for both consecutive and concurrent sentencing. And then ultimately, a good number of those convictions were merged by the trial court, and that is reflected, not entirely correctly, on the judgments as well. So I think when this court looks at the entire record, notwithstanding Mr. Cooper's testimony that he pled guilty, that he knew he took a 20-year deal, I think everything else indicates that he did not fully understand what that meant. For example, there's no indication that he understood which of his convictions were merging and which were staying on his record. There's no indication that he understood how his release eligibility would work, whether he was spending that entire 20 years in prison or some of it would be on probation. There's no indication that he understood which ones were concurrent and which were consecutive.
Excuse me, how can counsel explain that? How do I know how long he's going to be in jail or not?
So sure, I guess, I'm sorry, Your Honor, I don't mean that anyone could give him a set number, but I don't think there's anything in the record to indicate that it was explained to him how his release eligibility would work. They pled him as a range 1 at 30%. And I don't think there's any indication that he fully understood whether that was 20 years either entirely or partially on probation, depending on whether some were concurrent or some were consecutive. Because
okay, well, you're approving a negative and wanting me to accept it as a positive.
So
there's nothing in the record about it. So don't you bear the burden of proving beyond clear by clear and convincing evidence that something occurred?
I think we bear the burden of proving that under an analysis of the 5 Howell factors, that this plea was not entered into with full comprehension of its consequences.
And
Well,
are you using, I'm sorry, Judge Williams.
I just don't think you can do that by proving a negative.
Are you trying to show that because the judgments perhaps were filled out incorrectly, that supports your position that this was so confusing that he couldn't understand it? Is that what?
That is one part that I'm arguing supports our position. Yes, Your Honor. That's not
Well,
the. But
Let me ask you this. I mean, and I'll certainly ask the state's attorney this too, but we all agree, you both agree that these judgments need to be redone. Is that correct?
Yes,
And
Your Honor.
you agree, what do you believe the sentence was based upon your review of the record?
I think that it was an effective 20-year sentence to serve based on my review. Although the judgments reflect, I think that it's a 30 and possibly a 40-year sentence. I was looking at it again today, and it's still unclear to me whether the judgments reflect 30 or 40. But I think
So regardless of your claims for post-conviction, you believe the agreement was 20 at 30% on all offenses.
Yes, Your Honor.
Okay.
I believe that.
Are the agreements clear as to that?
The agreements say that it says the first one says effective 10 years. And then below that, it says effective 20 years. And I can't recall if it's that plea agreement or the second one that says effective 20 years at RG1. So presumably range 1. So that is on there. Yes, Your Honor. My point is I can figure that out. I can piece it together, but my client can't read or write. And so it's not whether I can figure it out, it's whether Mr. Cooper could figure it out. I think that's the real problem here.
So we don't need to worry about any of the paperwork. We just need to worry about what he was told.
The question is what he understood. That's correct, Your Honor. And my only point with the paperwork is that it supports that this was confusing, even for someone who can read or write, even for me as an attorney, even for whoever reduced those plea agreements to the judgment forms. And so certainly the question of whether Mr. Cooper understood, in my mind, that supports that argument.
So did he take the stand and say anything about what he understood?
He did. And so that's what's very interesting, Your Honor. And this might get to your earlier question about whether I'm trying to prove a negative. The trial court, in its order denying post-conviction relief, found, this is finding number 3 on page 90 in the technical record. The post-conviction court said the petitioner testified that he fully understood the plea agreement. That is not true, Your Honors. Mr. Cooper testified he knew he said, I just knew I was taking a 20-year deal. In the next sentence, or it may have been the previous sentence, he testified, I didn't really understand. So that's his testimony that he did not really understand what the 20-year deal was. The trial court then makes an erroneous factual finding that he in fact testified that he fully understood, which he did not do at this post.
Well, what do you mean by fully? Did he understand that he was subjecting himself to 20 years of confinement? Or you want the nuances of where he was going to serve and how he was going to serve and when parole hearings were going to be held or when disciplinary actions or when his release potential for release eligibility was? What is he saying? He didn't understand.
I think the first thing Your Honor said about the confinement part, I think that's really what this gets at here is whether it was 20 years entirely in confinement in prison. And that is the part that I don't believe it is borne out in the record that he fully understood the consequences. And this is from the case law, whether he understood what the plea connotes and its consequences. I think that's the key here. I think there could have been some better questions asked of him at the post-conviction hearing, just to be completely candid with the court. But I do think that his testimony that he didn't really understand flies in the face of the trial court's finding that he testified he did fully understand. I just don't think that that finding is supported by the record. Another finding that I don't think is supported by the record, I know I'm coming up close on my time here, is the trial court found that Mr. Cooper was malingering in the mental health evaluation. And I just want to be very clear with the court. His original trial attorney testified that there was some malingering in the final evaluation. The final evaluation of Mr. Cooper's mental health was done by Western State. That is in the record. It's at pages 28 to 29 in the technical record. Nothing in that report says anything about malingering. I'm not saying trial counsel made it up, but my point is that the post-conviction court's finding that there was a final evaluation that there was malingering. Again, I don't think that that's supported by the evaluation report itself. The court doesn't have any further questions. We ask that you vacate these judgments and allow Mr. Cooper to withdraw his guilty pleas, and I'll reserve the remainder of time.
Judge Williams, can I ask one more question, please?
Yes.
It does have to do with your second issue of ineffective assistance of counsel and the failure of trial counsel to disclose a potential conflict because he represented your client's wife, I believe it was. And the state says in their response that you can't raise that now because it was not specifically pled or raised in your initial claim. Are you waving the flag on that and saying they're right?
No, Your Honor, we addressed that in the reply brief.
Well, I kind of felt like your reply brief was waving the flag on it, to be honest with you.
We are certainly not waving the flag on waiver. I do recognize, as I said earlier, I don't think that enough questions were asked on that prejudice prong for the ineffective assistance. I do think that deficiency is proven. I think that the deficiency is there, but I do recognize that the prejudice, we have a higher hurdle, which is why we're focusing on the voluntariness standard. But I think the reply brief sufficiently responds to the court, or the state's claim that we waived that ineffective assistance claim. I believe we addressed that thoroughly in the reply.
But you do agree in your initial petition, or you just said ineffective assistance, but you didn't specify because trial counsel did not disclose a potential conflict. You did not claim that in your initial petition, correct?
That's right. The pro se petition alleges ineffective assistance. Post-conviction counsel argued, questioned trial counsel, and argued on the inherent conflict of interest that was litigated without objection by the state at the post-conviction hearing.
Was it addressed by the post-conviction court? Specifically addressed?
No, Your Honor. This post-conviction court did not make a specific finding on a conflict of interest. The court ruled only that there was not ineffective assistance. And I will note again, just to point out a deficiency in the court's order, the court said, this is in the state's brief as well, I don't even know what the deficiency was. No one has told me what trial counsel did or did not do. And the state claims that the post-conviction court meticulously reviewed the record. If the court had meticulously reviewed the record, the entire argument at the post-conviction hearing was about this conflict of interest. It's there. There's no question that that was the alleged deficiency. And that was what post-conviction counsel repeatedly asked trial counsel about at that hearing. So we do believe that it was argued sufficiently, and then the trial court's denial of the ineffective assistance claim would cover that argument for the conflict of interest. Thank you, Your Honors.
Very well. General?
May it please the court, Brent Cherry for the state. The petitioner pleaded guilty to various drug charges, and these are primarily methamphetamine delivery and sale charges. With I think there was one or two marijuana charges and a paraphernalia charge mixed in. But there were several charges over 4 cases. He was sentenced to a total effective term of 20 years. Subsequently, he filed a petition for post-conviction relief, asserting that his pleas were not knowing and voluntary and that his counsel was ineffective. With respect to the claim that his pleas are not knowing and voluntary, this court has already asked a number of questions about that, and it's important to consider this in view of not only this this defendant's history, but also to look at exactly how the court addressed this at the plea hearing. The defendant asserts that he can't read or write. He received a special education diploma. He lived with his mother all his life. He received disability payments all his life, but he has had prior experience with the criminal justice system. Petitioner asserts that he always relied on his attorneys, co-defendants, or fellow inmates to make his legal decisions for him. His counsel argues that Mr. Cooper most likely just agreed to say or do whatever his attorney told him was best. And he also argues that the plea agreements are confusing. But the record clearly shows the petitioner was able to interact with the trial court during the plea colloquy, that he communicated clearly and was able to understand all that transpired, both at the plea colloquy and during the hearing on the petition for post-conviction relief. Petitioner underwent 2 forensic evaluations. There were no more than 2. The first evaluation was determined that he was not competent, and then he was committed for 30 days for a more comprehensive evaluation. And the professionals came back with a finding that he was competent and able to assist his counsel in his defense. At the post-conviction hearing, the petitioner conceded that when he entered his guilty pleas in 2005 and in 2008, the trial court told him about his rights and he understood them. He then conceded that when he entered his pleas in 2019, he understood his constitutional rights and he understood Judge Allen's explanation of what he was pleading to and the sentence he was to receive. The petitioner complains about Judge Allen's finding that he was malingering when he underwent his competency evaluation. He argues that there's no mention of malingering in the evaluation submitted by Western Mental Health Institute. But at the post-conviction hearing, the petitioner's trial attorney, Mr. Thorne, testified that the ultimate diagnosis was that there was some malingering and that the petitioner was not being honest with the diagnosis team. Now, he was not questioned or challenged about the source of his information. We don't know whether he spoke with some of the mental health professionals or if there was some additional documentation. That's simply not in the record. But having never been challenged, Judge Allen correctly accepted the testimony that Mr. Thorne offered. When considering whether the petitioner's pleas were voluntary, Judge Allen relied heavily on the plea colloquy and noted that he gave the petitioner multiple opportunities to say whether he was guilty or not guilty of the charged offenses. The petitioner consistently told the court that he was guilty, and Judge Allen fully advised the petitioner about his plea and properly determined that the petitioner understood his rights and he freely and voluntarily entered the plea agreement. I'm going to go off my notes here for just a second because I think it's important to look at this from a perspective of exactly what is a defendant required to know, or what does he need to know when he's taking a plea. For those of us who have represented defendants in plea agreements, that can be a very grueling process. I've noted that in the civilian system, the plea colloquy is, if you will, less strenuous than it is, for example, in the military system, where it is a very, very meticulous inquiry. And as a defense counsel, I have fond memories of sitting next to my client and trying to help him answer the questions correctly so he could get the benefit of a plea. And sometimes we were unsuccessful. Sometimes it was simply because the client didn't have a lot of mental capacity, shall we say. But what really does the defendant need to understand? First of all, he needs to understand whether the charges that he is pleading guilty to are charges that he actually committed. Is he pleading guilty because he really is guilty? And does he admit that? Is there any impediment to that? And that's the area where we typically got caught up when I had problems with defendants. They didn't understand the elements of the offenses and therefore could not admit something that was required sometimes in some very difficult kinds of offenses, particularly in bad check cases, which we did a lot of in the military system, which require more elements than, for example, what you would have for a sale or delivery of methamphetamine. But Judge Allen went through those offenses one by one to determine whether the defendant was pleading guilty because he really was guilty. Now, the second part of this, we look at what he was charged with and what is he going to be punished for? How much is the punishment going to be? Now, if we look at this from, let's take a different example. Let's say I'm going in and I'm signing off to have a surgery. Do I understand exactly what the surgery is? Has the doctor explained to me what the risks are? and what the benefits are? Have I been able to weigh and measure those so that I can go in, be put to sleep, and essentially go under the knife? I may not understand all the details of exactly what the doctor is going to do, but I understand that there may be a risk, and I understand what the risk is if I don't get the surgery. In this case, the defendant understood that he faced a greater punishment if he were to go to trial. Mr. Thorne testified that the minimum that he would receive if he went to trial would be 24 years if convicted of these offenses at a range 3, or rather, I'm sorry, at a range 2, and that possibly he could get a greater sentence, and that some of these would be considered as range 3. So that was the risk. The benefit, he knew he was going to get a 20-year sentence at range 1, 30%, as opposed to 35% if you were range 2. So how much more do we really need to have this defendant understand when he's going in to plead guilty to his crimes? He knows he's committed these crimes, he knows he's guilty, and he knows what the protection is that the agreement is giving him. In other words, a limit on the punishment he's to receive. Now, is it necessary that he understand that he might be eligible for parole after 30% of his sentence, or that he might be eligible for parole, but he may not be granted parole until he's somewhere further down the road? We don't go there when we're doing these plea colloquies, because it's too speculative, it's too difficult to predict what's going to happen in the future. But the defendant certainly understood it was a 20-year deal, and I'm pleading guilty to these crimes, and he understood that he was guilty of them. Now, when we consider the claim of ineffective assistance of counsel, the primary thing that petitioner has raised here is the representation of the petitioner's wife in the same criminal matter. Now, there were other complaints that were raised that could be considered under ineffective assistance. The petitioner complained that Mr. Thorne didn't visit him as often as he should have. He claimed it was only 4 times, and he didn't keep him informed of what was going on. But he doesn't really hang his hat on that. The thing he's really concerned about, and that he testified about at the post-conviction hearing, has to do with this claim that he represented both the husband and wife in the same charges. As I pointed out in my brief, we have a recent case, Holland versus State, from 2020, where the Supreme Court, where our Tennessee Supreme Court considered whether a reviewing court could consider an issue not formally raised in the petition or amended petition for post-conviction relief. And I think we can agree that this was not raised in the original petition, and the amended petition did not address this either. In Holland, the court made this holding: Tennessee appellate courts may only consider issues that were not formally raised in the post-conviction petition if the issue was argued at the post-conviction hearing and decided by the post-conviction court without objection. Now here, certainly we had argument about this. The state did not argue this and did not address it in its closing arguments of the petition at the post-conviction hearing, and Judge Allen did not address it. So for that reason, under Holland, this is waived. And I think we stop right there. We don't go any further.
Was there some testimony at the hearing from the attorney about what he told the defendant about a conflict? And
yes,
that basically, it wasn't clear to me, were they already in a divorce proceeding at the time?
You know, Your Honor, that isn't really clear either. When Mr. Thorne testified, he was aware that they were separated and in the process of a divorce at the time of the post-conviction hearing. I don't see anything in the record where he talks about it being apparent to him at the time that they were going through the plea process, or when they were
That
pending
wasn't
trial.
clear from what I got from the brief, so I just wondered if that's anywhere in the transcript. We'll check the record.
No, Your Honor, not that I saw. Now, when we consider what Mr. Thorne's representation was to them, he understood that there was an issue that could possibly become a conflict for them, because on the one occasion they came home from a night out on the town. They found investigators in their driveway, and they were doing a search, and the petitioner gave his wife some drugs, and this was what they had both told Mr. Thorne, according to Mr. Thorne, that he had given drugs to her to hide, and she had ultimately told investigators, hey, these are drugs that my husband gave me. And they were both charged with possession of that drug. But Mr. Thorne testified at the post-conviction hearing that he had them sit down in his office, and he explained to them very clearly that this was a possible conflict, and that if they ever got to a point where they were pointing fingers at each other, that he was no longer going to be able to represent either of them. Now, why was it something that would be to their benefit for him to represent them both? That's not a really difficult thing to understand. This was a situation where the petitioner was afraid for his wife that she might lose her parental rights. Apparently she had a son, and she wanted to maintain her relationship with him. And if she were convicted, this might cause some problems. However, he never was able to take this by himself. The state charged both him and her with the possession of these drugs. So that never became an issue. But this is a situation where what the clients both wanted was the same thing. And there's
trial counsel testified to what you're telling us right now.
Yes, Your Honor. Yes, Your Honor.
I'm just curious, when at the hearing, when I guess the petitioner and his attorney started down this path about having a conflict, did the state object? That's not in the petition. That's not before the court today. Was there any objection by the district attorney?
No, Your Honor.
Why are we going here? Okay. And I know you weren't the trial. That's just curious to me why they didn't object at that point. Why? I don't, and maybe you don't know the answer to, none of us know the answer to
That's
that.
what I was trying to get at. Thank you for saying it better, Judge Easter.
I said it any better, but it just, it's just, to me, a curious thing. So, because it seems like from listening to your arguments and reading your briefs, that's where a great deal of the time was spent at the evidentiary hearing was on this conflict issue, which wasn't even claimed in the petition or the amended petition.
That's right. That's exactly right, Your Honor. Now,
Okay.
if it had been raised, then there probably would have been a motion to amend, and the court would have considered it, and then it would have been developed. But
Was it raised?
well, it was argued. It was never. But the way Holland reads and Yarbrough before that is that this has to be raised formally in the petition, and the court has to consider it. If it's not formally in the petition and it's argued and the court addresses it, then okay, it's a done deal. But that just didn't happen here. So those points have not been met.
But are you saying, though, strategically, though, the district attorney may have not objected just so the court wouldn't have granted a continuance so an amended petition could be filed to raise it? Was it a strategic decision?
Your Honor, honestly, I don't know if this works to support my my position today, but honestly, I
Those
can
are
see
the kind
why
of questions I love to ask, those that cause you to question your position. So.
Well, the way the law reads, Your Honor, it's still on our side. But strategically, could the state just fail to make that objection so that they don't give a heads up to the other side to move for amendment? Certainly, I think that's possible in reality. But even so, if we were to move to the merits of this argument, it still fails, because what we're talking about is not a conflict, but the possibility of a conflict. When we look at the professional rules, they require that if there's a possibility of a conflict, that the parties need to be informed of this. And then the rules also call for a written waiver of the possible conflict. But here, we never get to an actual conflict because the interests of the parties never diverged. What they both wanted was to reduce the liability or the exposure of the wife so that she wouldn't lose her parental rights. And they never got to that point. They never came to a situation where it was going to be beneficial for the husband to do something to her detriment or vice versa.
Isn't that part of the problem, though? If they had had separate attorneys, they individually may have been advised that here's a problem with
Well, even so, Your Honor, if they were advised, I mean, they were advised that there was a potential conflict by Mr. Thorne. And he advised them, hey, if your interests diverge, then I can't represent either of you and you'll have to get separate counsel. But if they had separate counsel, what might that look like? That could look like pointing fingers at each other. That could put both of them at greater risk. The wife could be at greater risk if the husband points a finger at her because he's saying, you know, she did this and she's going to lose her rights. And that's really what both of them wanted to avoid. So it wasn't successful. They were both charged and they were both sentenced. The record doesn't give us any information about exactly what the wife was sentenced to, but their interests did not diverge. And so how can we have a conflict, an actual conflict, when counsel did everything that his clients wanted him to do? So again,
you agree with Ms. Weingardner. I just want to get this nailed down, that this was a 20-year at 30% deal. That's what the plea was for.
Yes, Your Honor, that's perfectly clear from the advice that the petitioner was given, from what Judge Allen announced at court. And I think if we look through the judgment forms, although there is a little bit of confusion in the plea agreements, I think the judgment forms still ultimately arrive at a 20-year sentence.
So regardless of what we do, there will not be a need to amend it for request amended judgments.
I don't believe so, Your Honor. I think we could go back and look at them again, but I think the confusion was more in the agreement forms than in the judgment forms themselves. And so with that, the state would encourage this court to affirm the judgment of the post-conviction court and denying post-conviction relief.
Thank you, General. You have your 3 minutes.
Thank you, Your Honor. I was supposed to start by saying I misunderstood the state's brief, but the state has a footnote about 2 counts that I missed that should have been 6-year sentences that are listed as 10-year sentences. So at the very least, I understood the state to agree that amended judgments, in the briefs at least, that amended judgments were going to be necessary on a couple of these when Your Honors review those. As to the ineffective assistance claim, as counsel said, a great deal of time, or Judge Easters, this may have been your comment, a great deal of time was spent on this conflict of interest issue. And as the state conceded, there was no objection to that. That was clearly the only ineffective assistance claim that was pursued, or angle that was pursued at the hearing itself, again, without objection by the state. And it is true that the Supreme Court has said the claims have to be specified, but if they are not specified in the petition, then this court can review them if they are argued at the post-conviction hearing without objection and the trial court rules on them. I was just looking back at the post-conviction court's order again, just to be sure I didn't miss something. The post-conviction court says, this is in the state's brief and in the order, I don't even know what the alleged deficiency is, which again, as Your Honors clearly saw, it was the conflict of interest issue that was thoroughly litigated at the hearing. And in the order, the majority of that 3-page order talks about the voluntariness and knowingness of the guilty pleas. It is not until the very end, it's the last few paragraphs that start to get into ineffective assistance. And all that Judge Allen said was, there's certainly no prejudice in anything that counsel did or did not do. That's it. Now, there were separate ineffective assistance claims alleged, as the state has pointed out, but the focus at the hearing was on the conflict of interest. But by all accounts, the trial court didn't rule on any of them if it was supposed to specify each of the ineffective assistance claims that it was ruling on. Instead, the court said, I don't know what the deficiency even is, and there's certainly no prejudice. That's it. In our opinion, when the only issue on ineffectiveness litigated at the hearing was the conflict of interest, the only possible finding that can be going to in the court's order is the conflict of interest. Again, although it was not specified in the petition, clearly the heart of the hearing. We'd ask this court to reverse those judgments. Thank you, Your Honors.
Well, thank you both. We certainly understand the issues that are presented, and hopefully we'll get you an opinion out in due course. Thank you both for appearing. we are happy. I don't think I announced it to y'all, but we are happy to be returning to the courtroom in January. And hopefully we won't have a long respite. We'll be there for quite some time. So we look forward to seeing y'all in person. Thank you for your help this year and last year through all of this. It is with great help that y'all have been able to be flexible with us, and it is so much appreciated. It's wonderful to have good lawyers and in front of us, and cases that are well presented, and you both do an excellent job. So with that, Madam Clerk, unless there's something from Judge Easter, you have any comments to close the day? Judge Ogle, would you have any? Thank you so very much again. We'll stand adjourned to the call of the docket tomorrow afternoon.
Honorable court stands adjourned.